Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranaike. Welcome to, I believe, the sixth live Q&A session that we are having. In the past several weeks, we've had criminal law, contract law, public law, tort law, and property law, or land law, as it's suggested in some syllabuses. And today, we're going to begin with equity and trust. First and foremost, once again, thank you ever so much for joining me in this live Q&A series. Much like I've mentioned in the previous live Q&A sessions as well, this series was essentially crafted and it's made primarily considering the prevailing circumstances around the world, around the globe at the moment. And while law is a subject that we can prepare for in isolation, it's always beneficial to have a community built around law, and when we study it benefits a lot when you have someone else and a group of people, like-minded individuals, that you can bounce off ideas with. So having said that, this is my version of it as such. Bear with me on a weekly basis. I try to improve these sessions to reduce the latency, so to speak, when it comes to these live stream sessions. I'm trying to improve the hardware and software as well to make it so that there are no hiccups or speed bumps along the way. Right, now having said that, much like our previous live Q&A sessions, the idea here is twofold. On the one hand, I will be going through the primary fast-track theory components of this subject. Essentially, the idea is to not really have something which is deep-seated in terms of the theory, because much like many other subjects that we prepare for in the LLB or a law degree, equity and trust is quite bulky and there's a lot to go through, and in the time span that we have, it might not be possible to touch on each individual thing. So because of this, the fast track series here that we are doing is to look at it on a high level and to supplement what you are learning on your own, so much so that it'll help you think differently when it comes to answering problem-based questions or essay-based questions at that, as well as make the most use out of the substantive law that you've learned on your own. It might be from the university's perspective, the documentation and the booklets that you've gotten, or the subject guides, or the theory components as well, the textbooks themselves. So having said that, a particular number of minutes, so hopefully about 10 to 15 minutes, we will devote to looking at equity and trust in a high level, so to speak, to look at it in a way where you can incorporate the theory that you're learning into every aspect of your answers to not just pass but ace your examinations. And afterwards, I've already gotten a set of questions that have been posted on the community on the Law Simplified YouTube channel. So we'll go through those as well. And if you have any questions that you have that you want to ask me as well, you can do so by using the live chat box, so that I'll collate and collect everything that's there. And once the fast track theory component of this live Q&A session is done, I'll be going through that as well. Having said that, once again, I must stress, we are trying to look at this at a high level. We are not going to go through each and every single aspect of the law as it relates to equity and trust. That will take a month of Sundays on its own. If you'd like to have access to comprehensive pre-recorded masterclasses, fast-track programs, workshops, and webinars similar to this as well, you can reach out through the links in the description, or by visiting courses.thelawsimplified.com. You'll see these links appear here and there, as well as in the description, and you can reach out to me as well. There is a series of dedicated WhatsApp groups that has been created as well, where students have Q&A sessions on their own as well. So you're more than free to join those. Again, the links to those are in the description down below. Right. Now, having said that, let's jump straight into what I mean by the high-level aspects when it comes to equity and trust law. Now, unlike many other areas in law, maybe in your first year, maybe in level 4, such as contract law or criminal law, or even in some subjects towards the latter end of your syllabus, in the latter end of your degree, such as commercial law and company law. Equity and trust, and specifically that of trust law, is something that we will not encounter on a day-to-day basis. It's something that might be distant to us and we might be indifferent to, and because of that, I always looked at trust law as something that alienates whatever rules and whatever justifications that we had learnt when we went through subjects such as, for example, contract law. Because in contract law, it creates one-to-one relationships, and the parties are bound on a personal level as well, and they are bound contractually by virtue of consideration that is passed between the individuals. One person losing something and gaining something, and vice versa in terms of the other person. A transaction having to happen, so to speak. But when it comes to trust law, essentially, the primary aspect or the premise that was understood, that is required to be understood rather, is the fact that trust law deals, as the word itself suggests, with fiduciaries, essentially trust on the persons or the people themselves. So by virtue of this fiduciary relationship that is created, the ultimate objective then is to create a circumstance where whatever ownership or whatever rights that you have towards something is essentially split between two individuals. The actors that we talk about in trust law is primarily the settlor, the person who has the intention to create this trust instrument, the trustee, the one who's the custodian to fulfill the objectives or the intention of the settlor, and the beneficiary, the person who will ultimately get this benefit out of it. Now, unlike contract law, where third parties getting involved is frowned upon, so to speak, here the most powerful individual in this relationship, by and large, is in fact the beneficiary, the object as we call it. Now, having said that, what we study in trust law is meant to be within this rule set. We need to keep these parameters in place to prevent fraud from happening, to prevent unfairness from taking place, and to make sure equity is proliferated. Now, having said all of this and understood the premise, let's have a look at a fundamental way that we can think of looking at the different elements and aspects as well as the types of trust law. Because when we go into this subject by and large, the point that we need to understand, specifically considering the fact that this is not a subject that we are accustomed to on a practical level, is that we need to look at the base law, the fundamentals, so to speak, and see how every other type of trust, other than express trust, the ones made by settlers, manifestly are allowed by court as exceptions to that rule. Now, what do I mean by this? Generally speaking, the foundation or the fundamental rule of trust law revolves around this concept of the three certainties. Namely, you need to have in any express trust instrument these three elements which are subsisting in order to consider that this trust or this particular instrument is valid before the law. Namely, there has to be an intention, or certainty of intention. In other words, there must be what we call a certainty of subject matter, and then following that we need to have a certainty of object. So in other words, you need to have an intention of the settlor. He needs to have intended a particular beneficiary or object, a person, to get it, and then it needs to relate to some sort of subject matter. It can be land, it can be shares or chosen action, it can be whatever. It can be money in a bank account, for instance. But these three fundamentals, these three parameters are an absolute necessity as it relates to the rules pertaining to trust law. Now, why I say this is because fundamentally, every other type of trust that we do, every other type of trust that we will discuss in this subject, by and large, manifestly considers some sort of exception to this rule. Now, what I mean by this is that it's not illegal or it's wrong. Rather, we need to understand and appreciate those circumstances in which they are allowed and why they are allowed. So, for example, if we are to look at some of these exceptions, we have, let's say, a type of trust such as secret trust. Secret trust, on the one hand as half secret trust, or on the other hand as fully secret trust, exists by virtue of the fact that a court of law is willing to essentially step over or overlook, let's say, the fact that in the case of a half secret trust, the intention is only partially clear. You know that there is an intention, but you don't know what exactly it is. Or in the case of fully secret trust, it is completely hidden. We have no idea what exactly the settler actually wanted. Similarly, when it comes to both half secret and fully secret trust, there is a clear distinction. There's a clear understanding that you have, as a third party looking at a public document such as a will, might have no idea what exactly the intention or the object or whoever this particular trust instrument was supposed to benefit. So by and large, when we take secret trust, this could be considered as an exception to the rules pertaining to two of the three certainties. Namely, the fact that a court of law is willing to overlook the need for an intention, an ostensible intention, and an ostensible object being clear. Now, similar to that, if we take, for example, a purpose trust, so either a public purpose, which is a charitable purpose, or a private purpose, one which does not have a particular object at all, what you would notice is, on the one hand, in public purpose or charitable trust instruments, there is no specific object, there is no specific beneficiary. It is only a class of people. On the other hand, if you take something like a private purpose trust, there is no object at all. It is for a particular purpose. It might be inward for that matter. It might be a trust instrument to upkeep of graves, for example, or look after pets, and so on. Now, generally speaking, why I'm looking at this as exceptions to the rule is because what I've noticed in having done fast track and masterclass programs for students from all around the world over the past several years, and having provided feedback reports for hundreds of scripts that I've written, that students have written and provided, it's clear that students tend to look at a very regimented manner in which to look at trusts. So it's very templated and it's very forceful, so to speak. It's better to consider this subject as being quite fluid and to look at it at a higher, more appreciative level. Digressing a bit from that, this is just to outline something that I've noticed in students as well. But moving on from that, the third type, and this is something that is not expressed at all. This is essentially created by court. I consider these types of trusts, namely the constructive trusts, as being similar to get out of jail free cards, so to speak. Now, the reason why I'm saying this is because constructive trusts are opportunities that a court of law has to intervene in order to make sure some sort of redress takes place, that unfairness doesn't take place when it comes to parties themselves. Now, having said that, all of these are not essentially to suggest that this is an exclusive list where every type of trust instrument is considered, but I wanted to get your thinking up and running, so to speak, in terms of how to look at express trust instruments and where exceptions to the rule are allowed due to certain reasons. So, for example, in the case of secret trust, they are allowed to prevent fraud. Otherwise, if the trustee decides to run away with said property, the beneficiary falls short of the requirement that the settler intended him or her to have. If purpose trusts are not allowed for, specifically public purpose trusts at that, the outcome is that a group of people that might have gone short or a benefit that is available to the society at large might not be possible. Right. Now, all of these things being considered and looking at the grand scheme of equity and trust, always keep in mind that trust law is essentially a subset of a broader area of law stemming from equity. Equity, as contrasted with common law, refers to fairness and justice. Where there is an imbalance due to something being too technical, our court of law might intervene to provide redress. Okay, so that is a very fast track outline of trust law. If you want to look at a bit more in depth, a few aspects of trust law in terms of the different types of trusts and how they operate in terms of the objects, as well as what powers the settlor might have, the duties that the trustee might have. Make sure you check out some of the make sure you look at some of the fast track and masterclass pre-recorded fast track and masterclass courses which are available on my online law school platform. You can check those out in the links in the description below. Right, now that we've gone through our fast track theory, and I do see a lot of comments coming in as well with questions, since we need to go into those as well. Let's first look at the community itself. There were a few questions that came about in the Law Simplified community on the channel itself. I'll try to encompass as much as possible because there's a lot on the live chat as well. So let's try to go through each one in turn prior to that. So we have one question from Chanel. What needs to be shown in a promissory estoppel question to prove its existence? Chanel, thank you very much for the question. In terms of promissory estoppel, the key element in promissory estoppel is reliance. If we look at even in the context of contract law consideration, estoppel, in order to establish estoppel as a shield rather than a sword, the person who's relying on it needs to show that there was some sort of representation made, and in reliance of that representation, he or she suffered a loss. So reliance is the most important component. How are resulting and constructive trusts used as an equitable remedy, especially when dealing with matrimonial property? That is a good question as well, Anna. So remember, as I just mentioned in the fast track, in the fast track theory that we just did, constructive trusts, by and large, much like resulting trusts, are instruments that are used by court as well as automatically, implicitly, to make sure some sort of unfairness does not happen by virtue of the fact that a technical requirement wasn't fulfilled. So, for example, a technical requirement would be something like Section 53(1)(b), which states that any conveyance of land needs to be signed in writing and witnessed. But that particular statutory instrument itself, Section 53(2), allows for any constructive trust to operate regardless of the rules in place. So those sort of examples showcase how courts use constructive trust as instruments, or resulting trust sometimes. When the instructions are unclear, it return to sender essentially. All of these mechanisms are there to get out of jail free, so to speak, when it comes to judges and courts of law. Okay, that's quite a bit. Let me try to get the ones that are quite different. What is a good essay plan strategy when writing equitable maxims? That's quite a loaded question, because it really depends on the type of question being presented as well. I always note that you must never approach questions as a one-size-fits-all, because every question on its own deserves merit in terms of the approach that you take. But broadly speaking, when you take essay type questions versus problem or scenario based questions, you have to be very careful in the context of the direction that's provided to you by the examiner. So for example, in an essay question, your strategy in terms of equitable maxims would be to go deeper and to really dive into why exactly that is used and how it is used. But if you're using an equitable maxim offhand in a scenario-based question, just make sure that it services the purpose that you're using it for. So for example, in a public law question, justice hurried is justice buried might be a principle that you're using. So you might want to talk about that just to prove perhaps how the process has been taken too fast, and how by virtue of that the Article 6 fair trial requirement has not been fulfilled in the ECHR in terms of that particular case. That's a very quick example though, but let's try to get quickly into the question. So I'll put up the live chat right now so that we can have a look at everything together. I hope Anna and Chanel, I looked at a few questions. I'm not sure whether you're there live, but those questions were there on our community forum, and I just thought I'll quickly touch base on those. Okay, so just to get into our live questioning, there's quite a few. I'll try to go as much as I can, since there's quite a bit here. Okay, so let me try and put each of these within the context. It is a quiz close trust is a form of a trust instrument in itself, and the use case of it may differ though, in the sense of you're comparing it here to a resulting trust, for example. A resulting trust is something that will implicitly operate due to one of the three certainties failing. Whereas a quiz close trust, one which is very similar to that of a wills, for example, is more of an express trust than that of a resulting trust. Resulting trusts are more automatic or presumed. Whichever way, the point is that it's outside of the ambit of the choice of the settler. It works implicitly on its own. I'm not quite familiar with the other gentleman or whoever that might be who's commenting there. Unfortunately, I don't think that relates to a question in trust law. Isha asks a taught question. You've missed taught, Isha, by 1 week, but that's all right. Let me see if I can quickly go through it. Joint and several liability. Should one... I'm guessing you're trying to ask whether it's two separate kinds of liability or put together. So joint and several liability essentially works in one of two ways. In the one way, it refers to the fact that you as an individual, in terms of a defendant, for example, might be liable for more than one action in terms of multiple claimants coming into the picture. Or on the other hand, it might be multiple scenarios for which that you are being charged with, or rather you are being brought to court before. I hope that answers the question. Joint and several, meaning it's multiples. So multiple tortfeasors might also be the case there. Okay, Isha asks again, I think this is criminal law though, but nevertheless. Another question on theft, 1968. What is the AR and MR for attempt to commit theft? Not theft, attempted theft. So if we take broadly the context of theft itself and then supplement the completion of the actus reus, of the physical act itself, that is where attempt takes place. So anything that you do which is more than merely preparatory amounts to an attempt, essentially. So the example that I usually give for attempt is where you want to steal something from a person's house. You notice that there is a vacant, like there's an open window. You decide to do that. No attempt, no crime. You take a ladder all the way up to that. Still no crime. You keep the ladder on the wall itself. Still no crime. You climb all the way up to it, and perhaps even enter. You do have a type of crime there, trespass. You're there without permission, and it might also be considered more than merely preparatory. I do not want to detract too much away, Isha. I apologize, because we are going through equity and trust, but nonetheless. Okay, Sophia asks, hi, regarding tracing and equitable proprietary claims, Clayton's case only apply to bank accounts or current bank accounts, or are they one and the same? So broadly speaking, it applies to the principle of accounts. So it does apply across the board. Tracing, just for the unacquainted here, what Sophia is referring to in terms of tracing is where the original subject matter that had been in some form defrauded by the trustee, and where the court allows the opportunity for the beneficiary to go after it, where it is, for example, now with the innocent third party, or where it's not recoverable anymore, there's an opportunity to get the conversion of it in terms of whatever the trustee has done with it. So if, for example, a land was owed to the beneficiary and the trustee fraudulently sells it, that money the beneficiary may be entitled to. So that's what she's referring to as tracing there. Please, could you also explain how to apply Ray Denley, Ray Rasher in light of under the beneficiary principle? So that's a bit to unpack there. But generally speaking, if I look at, or if I consider and suggest to you the distinction there and how it works currently, you'll need to read it along with something like, for example, McPhail and Dalton, as it relates to the choice and even the power of appointment in terms of choosing a particular beneficiary. Okay, there's quite a bit more. Let me try to go through as much as possible within the time frame. Okay, quick question from Adin. Could you get a quick recap on formalities? Right, so we went through this in the beginning, Adin, in terms of the fast track that we went through. In terms of formalities, the basic foundation of trust law and in terms of equity at large is to establish that any express trust has what we call the three certainties, namely the intention of the settlor, the subject matter is certain and clear, and there is a clear defined object. There are exceptions to this rule, as I usually consider it, specifically in relation to looking at things like secret trusts, where by and large the court suggests and specifies that you do not necessarily need to have particular intention shown on a will, for example, or the objects need not be clear. Same goes for things like purpose trusts, where there is no specific object. You can have a class of objects. And it also goes for automatic ones that the court itself invokes, like constructive trusts or resulting trusts, where the intention is not there, but the court itself suggests and puts that in place. Besides this, usually when we try to establish express trust instruments, we are looking at two levels of formalities. One is whether there is a proper declaration in place. This is where these three certainties come into place. And then we'll have to look at the constitution of it. So that relates to the actual subject matter being transferred, or the hands that it's the transaction that's taking place. Most students don't really distinguish these two well, because what you need to remember is these go parallel to one another. The trust instrument is the only thing that's locking down the trustee to his objective to the beneficiary, because on the other hand, constitution is what relates to the actual transaction, where the settlor is transferring the property or the goods or the shares to the trustee. So when that happens, the only thing that is forcing him to do what the settlor wanted and giving it to the beneficiary is based on that declaration. So declaration failure means that the trustee in most cases, unfortunately, is not even bound to the circumstances. We have another question from Adin: how to approach a question on history of equity. It depends though. Equity is quite a broad area, so a good place to start would be how equity formed out of unfairnesses that occurred in the process of finding evidence of people being guilty. There is a playlist and an associated course that I do called History of English Law. Adin, you can check out the playlist on this very channel itself. There is a comprehensive set of lessons on the channel itself that you can go through in terms of the history of English law. It's a fascinating area. One major thing that you need to remember is that equity essentially stemmed from an individual called the Lord Chancellor, the court of conscience, essentially, as he developed it and nurtured it and enriched it across the following century rather, until we have it today. Post 1066 of the Norman conquest. So when you have a question as it relates to the history of equity, that's a very good place to start. start with how there was unfairness in determining guilt or innocence. Back in the day, guilt or innocence was up to God, as the realm, as the crown considered it. So, for example, if a person was charged, not even convicted, but charged and accused of, let's say, theft, for instance, they'll actually burn the person's hand and then they'll cover it up with cloth, and if it had festered the following day, he's considered guilty. That was the mechanism of determining guilt or innocence. So equity stemmed out of that, where the Lord Chancellor and his agents felt that this person wasn't guilty. When they wrapped this wounded hand, they would put ointment on it before doing so, when they felt this person isn't guilty. So when he came the next day, it wasn't festered. Therefore, as the law itself, common law, suggested, he couldn't be guilty. Have a look at that. Have a look at the playlist, because it's quite a lot to answer in just one go here. Mike, you're welcome. Okay, Sophia has another question. Do you have any tips for the structure in approaching equitable proprietary claim problem questions and private purpose trusts? Right. Now, if I am to give you a general idea, Sophia, the best way when it comes to an equitable proprietary claim question is to work backwards. In other words, look at it from the perspective of someone who's representing whatever the issue might be. So you work backwards from the cause of action or the claim itself and try to identify the fundamental issues that might be problematic to the person you're representing. Same thing goes for private purpose questions. The main issue with private purpose questions is, have a look at what is called a Pettingall order. A Pettingall order is a situation where the court of law, for the first instance, more than any other instrument at all, a court of law actually gives the benefit of the doubt to the trustee to see if he's willing to take on the burden of a private purpose trust instrument, because it is burdensome. Understand the main problem with a private purpose trust instrument also is the fact that there is no one that can bring the trustee to court. Every other instrument, there is either a pressure group at worst, or an object and a beneficiary that's going to sue the trustee for this, that's coming with a claim. So that's a good place to start by default and work your way backwards. I hope that's clear. You're welcome, Sophia. Quick question from Mike, I believe. If the three certainties are present and however there is a precatory word, will the trust be valid? What you've said is insufficient for me to essentially decide it, Mike, because by virtue of what you're saying here, perhaps it really depends. Remember the concept of express trust in terms of its fundamentals and what is expected from a court of law and what parties are expected. It's no different to contract law. What I mean by that is contract law sort of thrives on this concept of laissez-faire or freedom of contract. What that means is, as long as it's not illegal, as long as everything that is being mentioned in the contractual arrangement is one that is not imbalancing the parties in any way, shape or form, it will be allowed. As long as there's consensus ad idem, meeting of the minds, all of that is fine. Same thing happens for express trust instruments. The fundamentals of the freedom of trust still exist, just like laissez-faire in terms of freedom of contract. So it's really up to the parties to define how the contract functions, one after the other. I hope that's clear, Mike. Okay, I believe one final question here. In a half-secret trust with multiple trustees where communication is not done to all trustees, what is the law in this situation? Is there a binding trust on all trustees? Or is there a resulting trust on those whom there was no communication? Again, are there any cases? There is case law for that as well, Jazz. So I'll try to quickly answer this from the perspective of the principle itself. The question that you're asking in relation to the multiple trustees being in place, there's a few other factors that go into this scheme. The general principle is whoever is told is bound. That's the principle. But even in the case of whoever is told being bound, it's it's by and large dependent upon the communication time frame. Because remember, in terms of a half-secret trust, the communication must not only be before the death of the testator, settler then and testator afterwards, but it must also be before the actual execution of the will. So really, when we talk about communication, we need to think about that factor as well. It's insufficient just to think, okay, has all the trustees been communicated to? We need to also think about when that communication has taken place. Okay, thank you ever so much, everyone, for joining today's equity and trust session. I know there's a lot of questions. This is a subject area that is often misunderstood, primarily not because of the fault of anyone, but because of the notion that it's not something that we encounter on a day-to-day basis. So having said that, I appreciate you all joining for this live Q&A session. This is the end of the original series of live Q&As. We've already done criminal, contract, public, tort, property, and now trust law. Hopefully, if there is interest, and I'll put up a few posts later on in the week as well, we'll try to do a bit more peripheral subjects as well, such as jurisprudence, commercial law, intellectual property, conflict of laws, which is private international law, and perhaps even subjects more subjects on the outside itself, so such as history of English law, if for those of you who are interested in learning about the historical aspects of the law. But having said that, hope everyone hope these sessions as a whole were helpful. And for anyone who wants to have access to my courses, the mini courses, the pre-recorded masterclasses and fast track, and the online law school, you can reach out through the links in the description below. You can also join the WhatsApp groups and reach out to me directly if you want to set up sessions as well. Right, but having said that, thank you again for joining. As always, have fun, stay safe, and obey the law. Cheers.